Thank you so much
Thank you.
for giving us some of your time. I know you're very busy.
My pleasure.
I first want to start with some of the news that broke this afternoon that California's Republican Party is filing suit against Prop 50, which passed Tuesday night. They allege the new maps gerrymander districts in violation of the 14th and 15th Amendment. Your response to that?
Well, the people of California spoke loud and clear last night. It was overwhelming. It was without a doubt very clear support of Prop 50. I think the voters should be honored, and they were very clear about the fact that they rejected Trump's lawlessness and his efforts that have made groceries and other costs higher, and they want people who are hungry to have food, and people who are sick to have affordable health care, and they don't want militarized American cities, and don't want massed ICE agents roaming around in communities and neighborhoods, and also don't want tariffs making costs higher. So they spoke loud and clear, and I think that their will should be honored. I'll also say that this is one lawsuit in a litany of numerous lawsuits, all of which have been rejected by the courts, all of them. Up to now, this is a new one, so we'll see what happens next. But there have been many attacks on Proposition 50. This latest lawsuit is by the California Republican Party. It's funded by the National Republican Party. Again, the prior lawsuits have been rejected, and I'm not named in this lawsuit. The governor of California is, and the Secretary of State, Shirley Weber, are, so I would refer any additional follow-up questions to them. But my main point is Prop 50 was overwhelmingly passed by the voters of California, and the will of the voters should be honored.
If you'll allow me a more of a legal question on this, since you are a lawyer, I did find it fascinating that the basis of their argument is about racial-based gerrymandering. When you have a case before the Supreme Court right now with Louisiana versus Calais that argues that race shouldn't be taken into account when drawing congressional maps. So complete different opposites from really the same party. I mean, what is your take on that?
It's interesting to just acknowledge the contradictory nature of the hypocrisy that could be built in. But as far as the complaint, we've just received it. We'll review it. We'll assess it. No additional comments or thoughts on it until I have a chance to review it. And we're still identifying what our role will be. We'll likely be representing both the Secretary of State and the governor as they will be our clients. We'll be their attorneys. But this case is just getting started, so nothing else to add at this point.
The president on Truth Social had posted raising questions about vote by mail, saying the election was rigged against Republicans. He said there were going to be investigations into that. Have you been made aware of any investigations or what he's talking about? And what's your message to voters who rely on vote by mail to cast their ballot in California?
I don't know what he was talking about. It was a remarkable but not surprising rant. It's sort of par for the course for him. Seemed like he was almost like a petulant child lashing out because he knew he was about to get thrashed with Proposition 50. All the polls showed it was going to pass overwhelmingly, and it did exactly what the polls said. California voters spoke up, spoke out, passed Prop 50 overwhelmingly. Trump was not on the ballot and should never be on the ballot again. But his specter loomed large in the Prop 50 vote last night, and it was very much a referendum on Trump. So I don't think he liked that. And for him, seemingly, when he wins an election or someone he supports wins an election, the election was fair. If he loses an election or someone he supports or something he supports loses, then the election was rigged. And this is what he was saying with, not one fact, not one legal citation in his rant, and just no basis for it. The elections in California are safe, they're secure, they're accurate, they're reliable, they're lawful. I'm not aware of any investigation, any criminal investigation. So I don't know what he was talking about. It doesn't mean there isn't one that I just haven't been made aware of. Sometimes he does policy by Truth Social post. Sometimes there's no policy connected to it, and never is any policy connected to it. So a little bit hard to tell, but we feel very comfortable about a very sound, fair, reliable, lawful vote-by-mail process. I will say Trump seems to be very supportive and comfortable with the vote-by-mail process because he votes by mail and his family votes by mail. So it's, to your point about hypocrisy, another example of hypocrisy with Trump attacking vote by mail because it's broadly used in places like California, places that don't support him or vote for him, but he uses vote by mail himself.
So part of the reason you're in town is another Trump policy, his tariff policy, which is being heard by the Supreme Court. And the justices, during over 2.5 hours, seemed pretty skeptical of his argument that the 1977 law gives him this sweeping authority. What was your take on it?
Similar take. I don't agree. I don't disagree with your assessment. I think there were some really pointed, important, focused, thoughtful questions by the justices. There were some very, I think, telling and revealing comments. I think what really shined through and was a through line throughout the entire 2.5 hours of argument was the arguments that we've set forth, that tariffs are taxes, taxes are a very special and unique exclusive right of Congress, that Congress can exercise that right, that the statute upon which the president relies for imposing these tariffs against over 200 nations from 10% to 145% in their amounts never mentions the word tariff once in the statute itself. It has never been used by any president since 1977, almost 50 years, to ever impose a tariff. So that all shined through in the arguments, but I think that the court is full of constitutionalists who look at what the Constitution says and where powers are allocated. Are they in Article 1? Are they in Article 2? And it became very clear that the power to tax is clearly a power that is with Congress in Article 1, and that there has been no delegation of that authority to the president. And so I found some hope from my position as one of the plaintiffs, supporting the plaintiffs. We brought our own lawsuit in California. That's a separate lawsuit. But I saw some hope in that and for the outcome, and we'll see what the justices do. I will never predict or speculate on what the outcome will be, but from the statements made from the bench and the questions that were asked, I found a good deal of hope, and there was definitely a healthy dose of skepticism of the federal government's case.
And you brought up the fact that you and the governor brought another case based on tariffs. California, the 4th largest economy in the world. You were some of the first and most outspoken critics of this policy. Can you kind of remind us the impact that these tariffs have on California businesses and the California economy?
Absolutely. And Governor Gavin Newsom and I, on behalf of the state of California, brought the first lawsuit challenging Trump's unlawful tariffs. California is the 4th largest economy in the world. We're the largest state in the nation. We are the biggest importer of any state in the nation, the 2nd largest exporter of any state in the nation, the largest exporter of agricultural goods, the largest exporter of, the largest manufacturer in the nation. Our assessment suggests that these unlawful tariffs will cost California $25 billion in harm to the economy, and it will cost us 64,000 jobs, and so workers are getting hurt, and businesses are getting hurt, and mom and pops are getting hurt. And I've had roundtables up and down the state, one in Southern California, one in Northern California, another online with businesses, and they're telling me how businesses want what we all know they want. They want certainty, they want predictability, they want the ability to plan and have capital investments and expand, and they can't do any of that. In fact, they have to do the opposite. They have to lay people off. They have to halt their current projects and plans. They can't grow, they can't expand because of these tariffs that are so unpredictable and so harmful. So a lot at stake for California, and we're hopeful that we can deliver the people of California relief with a good result in this Supreme Court case, with a positive decision. And the people of California, the people of America deserve better. They deserve better than a president who is breaking the law and visiting economic harm and pain on them through his lawlessness and his law breaking.
And what people may not realize unless they own a business is the fact that while these lower courts have ruled the tariffs illegal, they are still in place while this plays out before the Supreme Court.
That's right.
There is a suggestion that the tariff funds may have to be paid back if the Supreme Court rules against the Trump administration. I mean, what would that even look like?
Well, first, you're right that all the courts that ruled on the issue of the lawfulness of the tariffs so far found that they were unlawful. 3 courts. The Court of International Trade, the District Court for Washington, D.C., and the Court of Federal Claims. And there's a number of ways that the court could address this issue. I think the first and most important issue is just determine if the tariffs are lawful or not. They are not. And then what the remedy is, is a second question. But the first question shouldn't wait for the second question to be answered. You just answer the first question: is it lawful or not? It's not. Let the chips fall where they may. They could order that the tariffs are struck down prospectively, going forward, from the time they make their decision going forward. Or they could also say that it's both prospective and retroactive, that all of the tariffs that were imposed unlawfully are struck down, and everyone harmed by them who had to pay them in the United States of America are due a refund, are due a reimbursement. And there's an administrative law process where you can petition for a reimbursement, you can have someone protest, you get due process in that process. You go before a tribunal who will assess your request. You provide support and evidence and documentation for the loss and the harm that you have. So it could take time. It could be a lengthy process, but justice, even if it takes some time, is important to be delivered. And Californians and Americans who are harmed by these unlawful tariffs, they deserve justice.
And it's expected that there are billions of dollars that have already been raised by these tariffs. And the president doesn't seem willing to let this go if the court does strike this down. The administration has suggested it would look at other avenues to potentially reinstate these tariffs or find other ways to try and place these taxes and make sure that more goods were manufactured in the U.S. or, imports just taxed on American citizens. So, I mean, like, what can California do moving forward, regardless on what the court decides, if he looks for other avenues to put these tariffs in place?
Well, we'll take it one step at a time. I think the first and most important issue and question before us, before the U.S. Supreme Court, which we've taken a strong position on, are these current tariffs, and they're massive. Again, applied to over 200 plus countries, billions of dollars being collected on these tariffs. That's how much it's harming the American people. And the first question is, are they lawful? And they're not, so we address that issue and then we move on. We see what the Trump administration does next. Maybe they'll sort of say, hey, this was our best shot at imposing broad sweeping tariffs, and we got it struck down, so we're done. Or maybe they looked at some other statutes that do authorize tariffs, and they're more limited. Some tariffs allow for tariffs up to 15% for 150 days. That's Section 122. They could potentially rely on that, but they won't be the same broad sweeping tariffs that have no time restriction, that have no limitation in amount. They have strict guidelines and restrictions on them. So they may pursue some other avenues that the law actually allows them to take advantage of, but we'll take it. I won't prejudge it. We'll take it one step at a time and see what the court does first, and then see what the Trump administration does next.
Something that likely flew under the radar on Election Day was the fact that you were able to secure a final stay on the Trump administration's attempts to withhold grant funding through the Department of Transportation.
Yeah.
That was a months-long process. Kind of take us back to what those grant funding pauses meant, and now what it means moving forward, being able to get that funding back.
Absolutely. The Department of Transportation tried to impose a unlawful immigration enforcement condition on their billions of dollars of Department of Transportation grants. These are grants that help keep planes in the air, help keep cars on the road, help build our infrastructure, our highways, our roads, our tunnels. And they were unlawfully trying to require states that wanted these funds to engage in their cruel mass deportation process. And that was a violation of our 10th Amendment rights for states that were expressing their sovereignty and had a different approach. It's a violation of the anti-commandeering principle, which says that the federal government can enforce immigration laws, but they can't commandeer or conscript or force states to do that job for them, or coerce them into doing that job for them. So we prevailed on that issue. We had prevailed on that same issue in other cases as well, with respect to the Department of Homeland Security and counterterrorism and cybersecurity grants that they tried to put a similar condition on, as well as VOCA grants, violence for victims grants. And so, victims of violence grants. So this is something we had won on multiple times in different cases, and then we're getting to a place now, months in on some of our cases, where we are getting final judgments, permanent injunctions, not preliminary injunctions, final judgments in a case, not temporary restraining orders. And what we secured in terms of the victory in the Department of Transportation case was a final judgment, a final victory at the trial court level.
I also wanted to ask you, when you were here last time back in May, we had talked about the fact that you still had faith in the court system as being a check on this administration. We are now in the longest government shutdown in our nation's history. We have the president threatening to potentially withhold SNAP benefits that courts have directed him to release, even if they are partial payments. Do you still believe that the justice system is able to provide a check on this president when congressional Republicans who hold the House and Senate refuse to do so?
100%. It is probably the main check on the Trump administration's unlawfulness. The Congress has been supine. They have been cowardly and craven. They have let Trump trample over their authority. The Republicans who are in the majority in Congress, they are not standing up as a co-equal branch of government. They are giving in and bending a knee and letting Trump do what he wants when he wants. The courts are places where I and my fellow Democratic attorneys general have been able to go when the law is broken. And that's what we look at. If we look at the boundary of the president's power and we say you can't cross this boundary. You can do lawful things. You have a lot of authority that is yours as President of the United States of America, but you can't do unlawful things. And we take him to court when he does. And we have been winning in court over 80% of the time. And in all of our cases, the presidential administration is following the court orders. So absolutely, the courts remain a place where justice is done, accountability is delivered. The unlawfulness of the Trump administration and his trampling over the Constitution has consequences, and we were able to block and stop his unlawful actions and make sure he's only doing lawful things. So maybe since the last time we spoke, I feel even more strongly about justice being done in our courts and courts being a place where the unlawfulness of Trump can be blocked and stopped.
Do you think the Supreme Court's reliance on the shadow docket that we've seen over the last several months, where they don't have to give an explanation for their rulings, potentially erodes some of that public trust?
I do think that. I think that the emergency docket or the shadow docket of the U.S. Supreme Court, usually where they're receiving a temporary restraining order or a preliminary injunction that's been issued by a lower court and deciding if they're going to stay it, halt it, block it for the time being as the case continues or not, it's been used more frequently. And there's not the transparency that you would hope for on the emergency docket. You know that whatever the decision is made, there's a majority of the justices, but you may not know who the justices are. And you definitely don't know their reasoning. They don't have a majority opinion that provides guidance to the lower courts, for the lower courts to follow. It's just a up or down, black box, hard to understand it, not knowing the rationale behind it. And sometimes you get a concurrence, but the concurrence is not the majority opinion. Sometimes you get a dissent. The dissent is definitely not the majority opinion. So I think it's confusing. I think it doesn't give guidance to lower courts, which is the job of the U.S. Supreme Court. And I think it does have the potential to erode trust. And maybe there's a time in the future where either the emergency docket is used less by the U.S. Supreme Court, or maybe they declare the votes for the decision, what justice stood where, and they give a rationale for their decision.
Does it change how you approach your job, or what cases you may bring before the Supreme Court? Because California is involved in a lot of litigation. How do you kind of manage that unpredictability with how you tackle a case?
We accept the system for what it is, and we know that the federal government is fond of taking appeal after appeal. Usually we beat them in the trial level, then they appeal it to the intermediate appellate court, and they seek a stay or if appropriate, a full appeal. And then sometimes if they don't get the stay that they want, they go to the U.S. Supreme Court, as they have in this case out of Chicago involving the National Guard, where they didn't get the stay at the Seventh Circuit, and now they're petitioning for a stay in front of the U.S. Supreme Court. So we expect it, so we can anticipate it. We don't know what the court will do. We know that the court is accepting more cases than in the past. So we always see that there's a possibility that the federal government will go to the U.S. Supreme Court seeking a stay on the emergency docket, and we build that into our strategy.
How has the loss of a nationwide injunction, of course that Supreme Court ruling back in June, how has the loss of that nationwide injunction impacted the application of the law across the board, right? We saw in California the judge say you cannot send in the National Guard, and then the president is able to do so in other cities.
Yeah, it's interesting. I think the CASA decision in June that ended universal injunctions and said parties to the case can get complete relief, but parties not to a case can't be given relief if they're not a party. And they also said that private plaintiffs, should they want broad national relief or another form of broad relief, can move forward through a class action. And so I think there's been sort of a pivot. Now private plaintiffs are seeking class certification and class actions. In our cases, as states, we are going to court, so we are able to get the relief. I think your question is a better question for the Republican AGs in states where they're not seeking relief after their funding is unlawfully withheld from their people, or their people have their rights or freedoms trampled on. So, but we're seeking relief. And in the CASA case itself, we went back down to the lower court and we said, in order for us to get complete relief, as the plaintiff states, we do need a nationwide injunction blocking this executive order that undermines birthright citizenship, and we got it. So I think it's definitely workable. I never thought that universal injunctions were appropriate as relief in every case. I never thought they were inappropriate in any case. I thought they were sometimes appropriate in some cases, and that's still something that we're able to achieve through complete relief in the complete relief standard for the parties in our cases, and private plaintiffs can do it through class actions. And on your question about the National Guard, I don't know if that would have been answered by a universal injunction. Every set of circumstances are different. There could be no emergency in one city, but actually an emergency in another city that justifies, there could actually be a rebellion, hypothetically, theoretically. There's been nothing close to a rebellion or an invasion, which is required to federalize the National Guard and bring them in. But the facts matter. And each set of facts could lead to a different result. In D.C., for example, has different rules. There's home rule in D.C., and there's the president is the commander-in-chief of the National Guard here. So not sure that a universal injunction would have been the determining factor there to block all deployment of National Guard, since there is some fact-specific components to justify the deployment.
Overall, 11 months into Trump 2.0, you seem more resolved than ever to continue to fight in court to push back against this administration.
More than ever. Full tank of gas, full of energy, ready to go, whatever's next. We've brought 46 cases in 41 weeks. We're moving at a fast clip in response to Trump, who is moving high speed, high volume with his unlawfulness. He's a historic president, historically unlawful, historically unconstitutional, and we need to move quickly, and we have, to stop him and block him from taking unlawful actions that hurt our states, that hurt our people. So we're ready to go with whatever happens next. I had hoped and continue to hope that the President of the United States of America wasn't so contemptuous of the law and the Constitution, didn't violate it, the law or the Constitution, so blatantly and brazenly and consistently and frequently. And every time he has broken the law and hurt the people of California, I have sued him. I've given him no passes, because there should be no passes in that regard. I've never said he's moving too fast, we can't keep up. I've never said this one's not as important, we'll let him have it. Never, and I never will. Every time he hurts California when breaking the law, we'll take him to court, and hopefully we'll keep up our record of winning over 80% of the time and really delivering relief and support to the people of California, who deserve better than a president who is unlawfully harming them so regularly.
Attorney General Bonta, thank you so much for your time. I really appreciate it.
Thank you for having me. Yeah. Great to see you.
Great to see you. And come back. Come back. Next time you're in D.C., we welcome you to come back again. We really appreciate your time.
Thanks for watching our YouTube channel. Let Spectrum News be your resource for balanced, in-depth political coverage. And click the subscribe button here. You can also download our app and watch us on TV to learn more about the candidates, where they stand on the issues, and more. We'll see you then.